Let's take a look at an introduction to collective bargaining. This course provides background on the structures, strategies, and skills required for collective bargaining. The institutional structure and legal rights related to collective bargaining vary by level of government, jurisdiction, and occupational group. National labor laws that govern collective bargaining and representation rights for federal and private sector employees do not pertain to state and local government workers. State and local public employees' bargaining and representation rights are enumerated whether authorized by state law and, less frequently, by local ordinance or executive order. Collective bargaining is the process whereby labor and management representatives meet to set the terms and conditions of employment for personnel in a bargaining unit. Certain legal factors help to frame bargaining and union management relationships. These factors are also influenced by and help to determine the strength and strategy of public unions. Identification of such factors is a necessary prelude to painting a portrait of the bargaining process. They include the nature of the bilateral relationship, the type of union security provisions, the kind of administrative arrangements, the range of unfair labor practices, and the existence of a dispute resolution or impasse procedure. It typically unfolds in 3 phases. First, organizing to bargain, second, bargaining, and third, administering the contract. Each stage is characterized by distinct activities which are discussed in turn in future courses. Each step is necessary to determine who will engage in negotiations. Bargaining unit determination identifies whom a union or other association in negotiation sessions will represent. An administrative agency, a statute, a union, or an arbitrator makes this determination. The criteria used in determining the composition of the bargaining unit vary by state, but the following National Labor Relations Board or NLRB guidelines are typically followed. Community of interest. Common job factors, for example, are similar position classifications, duties, skills, working conditions, kinds of work, or geographic locations. Bargaining history. This includes such things as prior patterns of negotiation, representation, or labor management relations. Unit size. Units that are too small can absorb too much of bargaining representatives' time, create unwieldy fragmentation, and create a whipsaw effect. Those that are too large may lack cohesion and a community of interest. Efficiency of operations. Bargaining structures may impede efficiency if they're a poor fit with existing human resource policies or procedures. Exclusion of supervisory or confidential employees. This is predicated on the idea that there's a potential conflict of interest in a unit that combines supervisors, management with employees. Election is the next step in this phase of the process. Identification of who is to represent the union in negotiations need to involve an election. The employer may choose to voluntarily recognize a union for this purpose. More typically, a representation election is held. Certain management tactics, intimidation, force, and coercion are prohibited during a representation election. The union must receive a majority vote in a secret ballot election to achieve recognition as the exclusive bargaining agent for workers in the union. State laws vary regarding the definition of majority vote in a representation election. The actual certification of the union as the appropriately constituted exclusive bargaining agent for the unit is done by the relevant administrative agency. Certification of the bargaining agent may be rescinded if workers become sufficiently dissatisfied. Selection of the bargaining team is a critical task. Each side designates a chief negotiator. In some states, other stakeholders may attend or comment on negotiations, but this is more the exception than the rule. In the beginning, more mundane preparations occupy the center stage of collective bargaining. Getting prepared involves studying the lines of the existing contract, collecting and analyzing relevant comparative data like wages, salaries, and benefits, and sorting through the bargaining priorities. Bargaining strategy needs to be clarified. The costs and benefits of alternative bargaining proposals need to be weighed carefully. Legal and behavioral considerations come into play here. Two legal requirements in particular require attention. Bargaining must be conducted in good faith, and the scope of negotiations is often prescribed. Although the term good faith is subject to multiple interpretation, the public sector has relied heavily on NLRB rulings and private sector case law to determine its meaning. The scope of negotiations is often addressed in the law, but contentious in practice. Conflict arises because unions want more prerequisites or perks and want to haggle over a broad range of issues. Vague statutory language, frequently specifying the scope to include wages, hours, and conditions of employment, fuels the debate over the legitimate array of discussable items. Mandatory issues are must-do matters that fall within the language of wages, hours, and terms, or other terms and conditions of employment. Permissive, may-do subjects about which negotiating teams may bargain if they opt to. These issues are neither mandatory or prohibited. Prohibited, can-do topics that authorized statutes, administrative agencies, or the courts have determined are not subject to bargaining or beyond the employer's authority to bargain. Mandatory subjects can be pushed to an impasse. Neither team is required to concede. Negotiation can be viewed as a power game involving winners and losers. William Ury advises negotiators to resist power games and focus instead on problem solving that seeks win-win outcomes. Principled negotiations, or integrated bargaining, sometimes characterize the proceedings at the bargaining table. At other times, distributive bargaining prevails. In distributive bargaining, hostility is high, relationships are consensual, bargaining parties are viewed as adversaries, and one side's gain is another side's loss. Principled bargaining is less prevalent and more conscious-oriented. It stresses identification of common ground, focuses on cooperative problem solving, and thrives in open, trusting environments. Integrative bargaining or principled negotiation lays out a list of suggested guidelines. Separate the people from the problem. Focus on interests, not the problem. Invent options for mutual gain, and insist on the use of objective criteria. When dealing with a thorny problem, leaders must be creative in order to move beyond impasse or avoid a breakdown in negotiations. Impasse proceedings are triggered when bilateral negotiations come to a standstill. If mediation fails, the next step is fact-finding. If such first resort options do not succeed, last resort alternatives may be needed. These include interest arbitration, distinct from grievance arbitration or rights arbitration, and strikes where available. Because strikes are prohibited in most public sector jurisdictions, binding arbitration is the most common means of achieving final resolution. Public sector arbitration cases most frequently deal with discharge, wages, suspensions, and benefits. The principal mechanism here is a grievance procedure typically provided in the negotiated agreement. Grievance procedures lay out the available steps or levels to resolve disputes about contract interpretation or implementation. Two key players in contract administration are the union steward and the first-line supervisor. Both must be intimately familiar with the provisions of the contract and well-trained in interpersonal skills and cooperative problem solving if contract administration is to proceed smoothly. Despite the knowledge, skills, and best intentions of stewards and supervisors, there are bound to be disagreements that lead to the filing of grievances. Grievance mechanisms provide a peaceful and fair way to address these contentious issues with minimal disruption of the workplace. Binding arbitration of grievances provides finality to the resolution of disputes. In recent years, unions have been under siege. Conservative reformers have criticized traditional labor management relations, including collective bargaining, contending that bargaining is an obstacle to solving the state and local budget crises caused by the 2008 recession. These criticisms have resulted in a set of reform proposals that reflect concerns identified with the liberation management tide. The ideas underlying these proposals have been translated into legislation. Union supporters oppose reform proposals and bills curbing labor power and weakening the collective bargaining process. The principle of fairness suggests that workers who opt with a democratic vote to have a union represent them should also be responsible for paying the expenses of bargaining and administering a labor agreement. There is a similar truth related to city government, where ordinary citizens democratically elect the government and, even if they voted against municipal officials, they still are obligated to pay city taxes. Labor advocates argue that the public sector collective bargaining is a tool to help resolve the budget crisis and improve the well-being of workers as the economy improves. Nonetheless, the salience of several of the right-leaning reform proposals was recently reflected not only in the actions of governors and state legislatures in the Midwest and beyond. As of this presentation, a sampling of the AFL-CIO watch list of states where anti-union legislation has been proposed has increased. Several states have enacted reforms earlier. Other reforms linked to public sector budget deficits have harsh impacts on public employees are in the areas of pension and health benefits. States and localities have also sought to reduce unfunded retiree healthcare costs. There is a need to rethink the ideas and inflexible structures associated with adversarial bargaining. Key concepts in labor management relations drawn from the private sector are inappropriate when applied in general to government. Concepts such as competition, market economy, and free contracts are defining characteristics in the private sector, whereas government is characterized by monopoly, politics, and sovereignty. The doctrine of hostility between parties is fundamental to traditional collective bargaining. The doctrine of harmony, critics argues, offers a more appropriate set of ideas and behaviors to guide public sector labor management relations. The public interest in public employment includes the following: maintaining a peaceful, stable relationship, safeguarding the rights of all public employees, protecting the rights of the citizenry, providing services in the most efficient and orderly manner possible. Cooperative problem solving is more likely to succeed when there's mutual trust, commitment, and leadership from all participants as well as from flexible, adaptive organizational structures. Among the improvements are better service, lower costs, improved quality of work life, fewer grievances, speedier dispute settlement, increased use of gain sharing, more effective discipline, and more flexible negotiated agreements. Although it is important not to oversell win-win bargaining and harmony-based solutions or to undervalue the merits of traditional bargaining, these examples suggest that public unions and managers should explore diverse paths. Recent experiments, however, point the way to promising experiences with cooperative problem solving.